In this installment, Allison Fehrman is being interviewed by Christine Shaverdian on the topic of removal and restoration obligations.
Allison, leases tend to describe end-of-term removal obligations using words like chattels, trade fixtures, and leasehold improvements. What do they mean?
Good question. There does tend to be some confusion because the words can have different meanings in different contexts. Also, legal meanings and layperson meanings sometimes vary. Chattels are pretty easy to understand. A chattel is something not attached to the premises by anything other than its weight. The chair I'm sitting on, for example, is a chattel. Trade fixtures are items attached to the premises, either for purposes of the tenant's business or as an ornament. The tenant usually has the right to remove trade fixtures during the term, but it all depends on what the lease actually states. Leasehold improvements don't have a clear meaning at common law, so they're often defined in agreements. Usually, we're talking about installations or alterations to the premises, like fixed partitions, flooring, light fixtures, HVAC, doors, suspended ceilings, wiring, and ductwork. Basically anything that cannot be removed without damage to the premises. Chattels, like furniture and movable partitions, and trade fixtures, like bolted-down workstations, are not usually defined as leasehold improvements.
Is there any overlap? How do we know what needs to be removed at the end of the term?
Well, sometimes the definitions do overlap, but that's mostly unintentional and regrettable. It's a good idea to be precise in the lease, and certain items should get called out so there's no misunderstanding.
That makes sense. What kind of items are usually called out?
Cabling, first of all. Landlords don't want to be stuck with a mess of cabling after a tenant leaves. This is why leases often state that the tenant is responsible for removing all of their cabling at the end of the term. Another example is something called non-standard leasehold improvements. These may include specialty finishes or things like bank vaults, shower facilities, refrigerated areas, etc. Some landlords agree to let the tenant know when it seeks approval for installations whether the item is considered non-standard.
So what's the difference between removal and restoration obligations?
Some items get removed and leave behind a gap, so the lease should address what needs to be restored. Restoration means to put the premises back into a prior condition. Any prior condition needs to be appropriate for the situation and capable of being achieved. Some leases call for base building condition, but that's not a static concept.
Okay, so reasonable wear and tear. Where does that come in?
That concept isn't well defined. We do know that the tenant is not required to put the leased premises into the condition of a pristine new building, even if the building was in that condition at the commencement of the lease, so making an exception for wear and tear may not be necessary. We know that reasonable wear and tear depends on the condition of the premises at the commencement and expiry of the lease term, on the purpose for which the premises were leased, and the nature of the tenant's business. The age of the building and the length of the lease are relevant to understanding reasonable wear and tear, but in general, it's a pretty unclear standard.
So assuming the tenant's removal and restoration obligation is clearly spelled out in the lease, what happens if a tenant doesn't comply?
Ultimately, the answer lies in the lease. There could be some rights outside the lease pertaining to abandoned property. However, that's a conversation for another day.
That was Allison Fehrman in conversation with Christine Shaverdian on the topic of removal and restoration obligations. If you would like to learn more, contact Allison on our website, dv-law.com.
This audio recording was a general discussion and should not be relied upon as legal advice.